And I was just hearing to the previous session. I mean, the speaker is a good friend of mine, and the wonderful thoughts which he presented. See, you might get disappointed the way I have planned this, and I have a discussion with Rahul. And the way I have planned this is that I'll have a very small presentation, 15 minutes, and I want to take more questions from you people. Okay? Now, uh, shall we? And you have every right to stop me, ask me question in between, and also towards the end. And although I would prefer questions more towards the end because that disturbs the continuity of the presentation, and we will take it that way. And Rahul, shall we start with the presentation? See, when I'm talking about this, IP acquisition, this is a big term. It's a fanciful term. It's a term which attracts a lot and doesn't creates a lot of question on how you really want to acquire IP. Every researcher on whichever side of the table is sitting get carried away by this word. That's what I do. That's what I want to stop. See, when you are in business, see, IP is a tool to help you in your business. An IP acquisition is one of those specialized category tools. Now, IP acquisition, if you really ask me, it's going to be whether you are going to buy IP. You buy so many things for your requirements, for your normal function of life. The same thing is, do you need to buy something for your regular functioning of business? Or I am going to change this IP acquisition to a little different mode. As far as I've understood from Rahul, is that we do not have many acquirers who are in this forum. There may be people who want to sell their IP. That's also IP acquisition. Who the other guy, where you are on the receiving end, or you are trying to sell. So let's look at that IP acquisition with a new term, IP transaction, so that we understand as and when required, you are on which side of the table. Now, see, this is business, hardcore business. And there's a lot of money involved in it. There's lots in stake. Whether you're a startup or a mid-sized company or a big-sized company, when you talk about IP acquisition, there's a lot of money in stake. So every decision is important, critical, and has to be taken with a lot of exercise so that you get into a meaningful conclusion. I have a simple mantra for that. Okay, whether you are selling IP or getting IP or buying IP, the question is show me where is the money. If there's no money in that, if there's no benefit in that, this acquisition doesn't really work. Now, why has this become important? Just let's look at it. Why were we talking about IP acquisition so much? Because it's sometimes an easier shortcut. Okay. And the reasons why this is an easier shortcut is that there is a huge growth in mega licensing. You'll find, the entire portfolios of company A being, acquired by company B. So, like Microsoft Enter IP was acquired by Google. There's a boardroom pressure because IP all along has been a cost. Now, if you want to make it as a revenue, there's a pressure. Of course, there's going to continue as always a debate between patent quality and quantity. Quantity gives you muscle power, quality gives you an edge. Okay. And then, things have become so nice and improved that we have more and more patents being granted every year. The number is on the rise. That also creates a pressure. And fortunately or unfortunately, whether it's Wall Street or the Lal Street, they have all started taking an interest in IP. If you get a chance to read Wall Street journals, you'll find that there are frequent articles on IP acquisition and IP issues. Additionally, IP licensing is now a profit and loss drawn business. It's a P&L unit in the company. I know of so many companies, so many organizations where this is a business unit, which has led to a tremendous amount of internalization. And, and to add to this, there have been tremendous amount of legislative and judicial changes which helps it. There's an increase in standard essential patents. There is an increase in the damage cases. People are going to get, have been able to get higher damages. Hmm. And of course, when we talk about size, yeah, of course, portfolio size matters. Okay, may not be in theoretical matters. If you have a bigger portfolio of 1,000 patents and I have a portfolio of 20 patents, size, muscle does matter. But having said that, I will also say that if your 10 patents are so critical, it can knock off that 1,000 patents. See, and neither the cost and the expense are linear in this aspect. Now, why you want to acquire IP? The question is why you want to acquire IP? Because you can't build it, or you can't build something which is non infringing, or you do not have the time to build it. You want to get into business. Whenever one wants to acquire an IP, the conflict is between build and buy. Can you build the same stuff, or do you want to buy it? And the questions and the others aspects which are important are what is the timeline, what kind of skill you have, what is the research cost, development cost, who are your competitors, Hmm. and then taking it forward. Sorry, Hmm. there is always an uncertainty of success. Every development program doesn't really take you to a success level. Okay, so and what kind of budget you have. That's when you want to buy. But when you have a developed IP and you want to sell, that's also part of IP acquisition. What do you need to see that what kind of shares you have, on the market share you have, what kind of control you have on the IP. And remember, when you give your IP out to somebody, you might be giving birth to competitors who will be competing against you. So you need a more justified, able, diligence to be done so that you have meaningful uh, progress on the business. Now, having said that, I would also want to say it's not buying and selling anymore. When you talk about IP, it's not just acquiring IP, I buy somebody's IP or I sell my IP. The entire game is on licensing. When I don't buy the license, I don't buy the IP, I take a license to use over uh, over agreed territory, over a, you know, uh, agreed terms and conditions where I license it, which has some advantages because some of the liabilities of that IP still stays with the owner. You're not buying it. Now, I, I should also point out that IP is not, when you talk about business, when you talk about acquisitions, it is not just IP. IP will lead you to patents, copyright, trademarks, geographical indication, trade secrets, and if you are in agriculture, plants, variety act, whatever. IP doesn't end there because business करना है, धंधा चलाना है. So beside intellectual property, there's also something known as intellectual capital, okay, which is basically, you can see these are the human capital people who run it, the organizational capital, okay, and the technical know-how. You need to know that as well. So all that put together, I would say it's nothing like in a transactional process. Every business transaction which you and me do, it is no on for our daily livelihood, it is no different from that. So I thought of looking at a definition of business transaction. And what I found is that it's an economic event that indicates accounting process of recording in a company's accounting system. Okay, that could be even be a garage sale. But when you look about IP transaction, there should be something intangible in that business transaction. Now, this is a very simple but overcrowded slide. What I mean by that is that this is the complete cycle of IP transaction, where you have here on the left who generates IP, and here on the right who utilizes that IP. Now, you can go through one or multiple processes. I'm not going to read all of those out. You can have a look, which takes you there. It's not that you need to go through all of them, at least you'll have to go through some of them. Now, that doesn't mean that you generate an IP and you sell it for somebody or assign it to somebody or license it to somebody. You can use your own IP for your own production. I mean, that's the business cycle if you are internalizing your IP. And mind it, if you ignore it, it's lost forever. Okay. So you can't get out of this cycle. So what's important? Important are three things: goal, plan, strategy. You need to have a transactional plan, you need to have an IP strategy, and an effective means to say what is the value of your IP. Is it just those, those half a dozen sheets of paper in which you print your patent? That's the value of your patent? Or you can put a dollar value to that, which is higher, which makes business sense. So, what kind of transactions are we looking for? When you're looking for IP acquisition, there are only primarily three kinds. You can license your IP, you can assignment. Assignment is nothing but a sale, or you can look at, you know, uh, technical know-how transfer. Okay, it's a know-how transfer, often accompanied with licensing, but need not be with licensing in most of the cases. Now, when you look for your acquisition of IP, what is the first thing that should come in your mind is how strong is the target IP? Do you really want it? And what benefit does it do to you? Okay, that's the overall picture. When you dive deep into it, you have to see who owns the IP. Is the ownership clear or is it licensed? Are there third party users? Are there pending litigations? Are there pending oppositions in the IP offices? Or could that be rectified? Or there are existing infringements of your IP already? What kind of license agreement you want to get in? What are your security claims? And never ignore who are going to be your competitors. See, this is not a process of documentation or improving your CV. I'm talking here where, there are lots of money at stake. It's a business decision. So how do you go about? The goals vary. If you are buying an IP, what is expected is that you understand the business. Okay, the target. Your target is that IP which you want to buy or you want to acquire. You understand the business. You look into the assets and liabilities. You look at the price, and negotiation is always welcome. Whoever buys it always wants at a lower price. Whoever sells is always wanted a higher price. I mean, that's no different from the way you buy vegetables. And then finally, you reach to a consensus where you have a value, and you can put a dollar value to it, and then take it across the way you would like to proceed. So all that, sometimes I'm not saying that it's right or I mean it's the way it goes. It is that there may be liabilities, there may be mm, pending litigations, there may be anything. But what's important is that when you acquire that IP, you are conscious about it. You know about it. They're not some flimsy sudden surprises which comes up like a fairy tale tomorrow, mm, and hits you where it hurts the most. When you are on the other side of the table, you're like mm, you are selling your IP. You have to understand your acquirer. You have to try every means to increase the value of your deal. The more you get on the deal value, is the more you can make. Is more on your uh, earnings. Now, how to start? Without any confusion whether you are this side of the table or that side of the table, it doesn't matter. You have to do an NDA, a non-disclosure agreement, and find out what you are trying to protect, what you are trying to sell. What are the rights, what are the termination clauses, and who's receiving what during the discussion. Followed by an NDA, you need to. I mean, what's the normal procedure is an IP audit or a due diligence. I would not like to buy your IP or license your IP if I have not done a proper due diligence. Okay. So, what's the IP? What's contributing? And what are the risks? What are the liabilities? I mean, what are the license issues? I need to know all that. Okay. So, IP transaction, there are operating companies, there are non-practicing entities, then you have trolls, okay, you have aggregators, so on and so forth. I mean, this may not sound that the big, but in practice, it has been observed that larger portfolio gives you bigger muscle power. When you're trying to sell or license, you know, a single patent or two patents or a portfolio of patents, of course, the portfolio has a higher value. Okay, and the so larger value gives you more muscle power, gives you to establish more internal licensing teeth. What are the common issues? Transfer information, valuation and composition, allocation of liabilities and risk post. What are the termination rights? Often ignored, but the most important is that when the agreement or the license terminates, what happens to the IP? And if there are any required or essential remedies. So, what's the key to success? Now, this is just an overview of that. What's the key to success? Is you demonstrate what's your clear value, try to understand the portfolio in larger detail, and make your claim charge properly. mm, prepare your licensing needs, and look at the budget and what could be your possible competitions, and so on and so forth. I would like to stop here, okay, and look at what are your questions.
How IP should be valued? Any specific method?
Well, this is a very interesting question, because there are several models available how to value. So finally, you can't say that I have a great IP, it's immense value. You have to put a figure to it. Now, the most popular method is the cost method, how much you spend. Then there is a market method. Then there's a projected sale method. So these are models which are interesting, and I would suggest that one should take the help of more than one models, mm, so that you get to a more meaningful conclusion. These models are available. You have to you start with certain assumptions, and then try to get a numeric value to that. What are the best strategies for licensing academic innovations? How to bring more seriousness?
Hmm.
Hey, hi Amit, I hope you're doing good. See, the thing is, uh, there is a difference in functioning. Okay, let's accept it. When we look at industrial research and academic research, there is a difference of approach. Most people who work in academic research are very temporary, and they move out. It is the job of the supervisors and the PIs to take that forward. Now, the question which you say is that what is the best strategy? The best strategy is same as everybody else. And what is that? See, if you want to sell, you know, see, if I want to sell, one basket of mangoes to you, I should know that you want mangoes. If you don't want to buy mangoes and you want to buy guavas, then I mean, me approaching you is a foolish endeavor. So I should know who needs this technology. And how do I know that? It is true. Just a proper competitive intelligence search. There are so many search tools which are available to see who are the people who are involved in it, and approach them in a manner that you know mm, that I can fill in some of your gaps. See, I will not see. I would, as an industry guy, I may not like to, show interest in your IP unless it fills in some of the gaps which I am facing. In today's world, it is so easy to find that out through patent search, and even non-patent technologies, document search. That's one of the easiest way. Now, how to bring seriousness? See, how to bring seriousness is that, people get serious just before the exam. All students get serious before the exam, no matter what kind of lifestyle they lead all through. Now, when you want to do that, it is a success story which brings seriousness to others. It is a success story. So you can do research, you can do basic research, you can do industrial research. If it is of no use in the today's business, you might be just happy to publish papers. If you have an IP, then you have to be very, very conscious of what are the business requirements on this, and approach people who are in the same domain, who are in the same field, and can really benefit. That's your negotiating power. So the next question, anybody? Vijay, Satyaraju, CSR,
There's one from Darbha Shastri. Is
take
it
it.
true potential? IP valuation that counts, or is it influence on share market?
See, I mean, this is a very complex question. When it being in share market, you're talking about equity, okay, where the share market, where the NSE, BSE, is a controlling factor. Now that happens only for big companies. Okay, big companies are listed in the stock exchanges, and the stock market does influence that. It does get influenced by that. Now, big companies are not usually available for selling their IP. The more is the smaller companies, the startups who build something, and want to really quit by making some money by selling their technology and IP to somebody of mid size or bigger size. So when that happens, because most of them are not listed in the stock exchange, there is no influence of the stock market. Okay. Now, what's important is you get to do some mm, proper due diligence and get. See, I will tell you something. Vijay can wait. What's that? Is when you do a due diligence, you know, the the easiest thing is on a technology, try to put red and green flags in the technology. The green flags are okay for you. The red flags are not okay for you. And when you're buying or acquiring an IP, try to get maximum red flags and use them to negotiate to get a comfortable pricing for buying. Okay. See, IP negotiation is is not as simple as normal commodity negotiation. Sometimes you have to do due diligence. Sometimes you have to get into to see the POCs whether they work. And uh, I have seen, you know, mm, finishing negotiation in half an hour and taking 8 months to close a deal on IP acquisition. So it depends on who is the party, what you're organize, what you're trying to look at it. Let's get back to the question. Vijay, you're saying something. CSR patents are industry oriented, but still more than it. Ah, Vijay, you are doing a survey with all. I know because see, Vijay works in is with the Manipal Institute of Higher Education, and we collaborate on certain things. Uh, so you really think all the patents which the CSR publishes or gets are industry oriented? Not all. If they are, industry will take them up like anything. If they are of any importance, it solves a critical issue of an industry, they will be picked up by industry. There are multiple patents which are which are important to several industry domains, which have originated from CSIR. I would say, like CSR Institute, like I can mention at this, like NCL, IICT Hyderabad, DRDO Lucknow. Now, that doesn't mean others are not working. I'm more familiar with these. Mm. They have come with so many industry projects, have done well, and their technology has been absorbed in multiple industries. But if your patent is valuable, it will be picked up. Its valuable is a overall industry domain conclusion. You think it's important because you did industrial research is a perception. That may not be a reality in the commercial world in many cases. Okay, so what do you have something more?
Yes, sir. Recipe. Okay. I think it's a patentability question.
I am not food technologist, but I prepared one recipe. Okay. See, when you look at patents, there are several types of patents. Okay. One is a product patent, the other is a process patent, the other is a method of use patent. This is the normal nomenclature. If you get to ICT, then you have a method patent and a system patent. Now, what you say is a recipe is a process. Okay. According to the Patent Act of most of the countries, you can always patent a process. So, if you have a recipe which you think is worth patenting, and it qualifies for all the patentability criteria, like novelty, utility, industrial application, non-obviousness, etc., you can always get a patent. But the challenge is going to be somewhere else. You know where? Nabi, the challenge is going to be, how do you monitor infringements? Okay, you're going to make this patent, and see, the patent documents are all public. And if I use your recipe and follow that and cook the same dish at my house, how are you going to monitor it? Now, you will not be bothered because I'm making it for my own consumption. You will get bothered if it is a commercial use, somebody is using your recipe to make money. It's very difficult to monitor, but in as per the law statute theory, you can get a process patent on your recipe.
Yeah. We have one question from Sai Datta Vamshi. He's saying, isn't there a lack of clarity, certainty in Form 27 filing and commercialization of patents?
See, this is a very, Sai, I feel you are a practitioner, so you got the pain of Form 27. What's Form 27? Form 27 is a form which you need to file every year, okay, and showing the utility or the usage of the patent, because the Indian Patents Act, this is all these are all Indian Patent Act. The Indian Patent Act also says that if you have got a patent and you have not used that patented process for 3 years, then it can be open for licensing. Okay. And if there is an issue on licensing, then the interested party can approach the patent office for a compulsory license. Okay, that's a far-fetched thought, but that's what the statute and the law provides to every Indian citizen. So you need to disclose what you do. That is, in a way, sometimes you feel, I would agree and disagree both, because I agree because that goes against the philosophy of patents. The philosophy of patent is that, it's not getting a monopoly, it's stopping others from using. And then, that's where I agree. Where I disagree is that if you're not utilizing a patent, see, your patent may be a very not so important or a trivial patent. Think of a situation where I have a patent for a life-saving drug and I don't manufacture it. It's my choice. Because I have a patent, nobody else in the country can manufacture it. You getting me? I have a patent, I don't make the product. It's a life saving drug or a life saving, invention. I don't make it, so it's not made by me. Nobody else can make it because I have a patent. And it's the country and the citizens who suffer. These provisions are actually built in with those situations in mind, which are not common, which doesn't happen every day. Can we move on to the next one?
Yes, let's see. Is there any helping guiding available? for individual inventors in the process of selling licensing or any channels, or maybe I think they are asking.
So the question is, uh, see, there are accepted, recognized help for uh, getting an IP, filing a patent, going through it, and with subsidies. Now, whether you're saying selling and licensing, this is called IP brokerage. Okay. IP brokerage, there are firms and companies who do that for a living. Okay. Now, IP brokerage is no different from getting a tenant for rent for your house. So it's a technology which you want to license out, which is similar to the house which you want to give for rent. So there are IP brokerage companies, multiple of them exist. You can approach them with your portfolio and ask them to find a proper guy who would like to license your technology and then agree on the commercial terms and go forward.
So Dr. Swati Joshi, she's asking which is better, licensing or tech transfer? Should we create our own company for selling the technology or giving up the rights to someone?
It all depends what you want, Dr. Swati. What you want, okay? When you build a house, it's your choice whether you want to live in that house or give it for rent or after 2 years sell it. It's your business wish. I always give this house example. When you build a house, you're free to stay at it. You are free to give it as a rent. You're free to mm, sell it after some time. It's your choice. Now the same thing, just remove that house and bring in your IP there. License is nothing different from renting. Assignment is nothing different from selling. It's your business model which you want, and there is no answer for this. There is in certain situation maybe licensing could be better. In certain situation, assignment of IP could be better. Okay. Tech transfer is something which usually in current world doesn't work without assignment or without licensing. I cannot transfer a technology if I don't give him the license to use it. So tech transfer is usually goes hand in hand with licensing. So it all depends. What's your business plan? What is your future, way of revenue plans, and take a decision like that. I hope I could answer your question.
Let's take a few more questions, maybe one or two. So, can a criminal case be done to infringer of a patent?
This is a very, very basic question about patent. You know, when it's trademark or copyright, you can go for a criminal case. When it's patent, it's a civil case. That's how the law and the statutes are. Okay. So what happens if there's an infringement? Okay. If I infringe your patent, what can you do? You can take me to the court, prove an infringement. Okay. I have to pay damages and penalty. This is a civil case. You cannot put me behind bars. But if it's a trademark or a copyright case, you can actually put me behind bars. Not in the case of patents. That's how the statute is. Because most of the time, uh, the patents are owned by legal entities, not individuals. They're owned by organizations, where this kind of remedy works much better than the other. So, do we have something from Rajiv Patel? No, this is Rajiv Patel. Okay. Anything else?
Defense equipment, defense use equipment, can we patent? Rajiv, okay, this is okay.
There's another question from Rajiv. Can we patent defense use equipment? I guess you know the answer. This is Section 6 and 7 of the Indian Patent Act. The answer is you can apply for a patent. It is evaluated by the patent office and the ministry. And if it is of importance of national security, you can't. Otherwise, you can. So, if you look at Section 6 and 7 of Indian Patent Act, which talks of defense security, atomic energy, and which are involved with the security of the country. If you have an invention which involves all of these, then it would be evaluated by the respective ministry. And if it's of not of interest or not of damage to the country, you can have a patent. Otherwise, uh, and your application just gets lost in the patent office.